Good morning, this is your Kelso Report for Monday, May 14th, and I'm your host, Clark Kelso. Well, we've got quite a few cases, so let's jump right into them. We begin with the Ninth Circuit, a criminal law case involving cultivation and distribution of marijuana. In United States v. Hang, the defendant was convicted and sentenced to 10 years imprisonment for conspiring to manufacture and distribute more than 1,000 plants of marijuana, and for manufacturing and cultivating and aiding and abetting the cultivation of more than 1,000 marijuana plants. The defendant failed to object when a law enforcement agent testified regarding statements the defendant made through an interpreter during a post-arrest interview. On appeal, the defendant argued the interview likely constituted a plea discussion, and that the district court should have sua sponte raised the question of whether the defendant was waiving his right not to have statements made during a plea discussion used against him. The Ninth Circuit rejected this argument, holding that even if the discussion was a plea discussion, the burden was on the defendant's counsel to raise an objection, instead of it being on the court to try to determine whether the particular interview was or was not a plea discussion. The Ninth Circuit also rejected a hearsay exception to testimony by a law enforcement officer, rejected hearsay objection to testimony by a law enforcement officer who tallied the count of marijuana plants which were found by the agents. Although the final report of the number of plants was the result of essentially triple hearsay, the court found that each of the layers of hearsay fell easily within traditional hearsay exceptions. The Ninth Circuit affirmed the conviction and a sentence. California Supreme Court granted review in 4 cases that are of interest last week. First, as you know, the Supreme Court of California held in People v. Romero that trial courts have discretion to strike one or more 3 strikes findings. Well, in People v. Smith, the 2nd District vacated the defendant's 150-year to life sentence after being convicted of custodial possession of a weapon, 2 counts of resisting an executive officer, and 3 counts of battery by gassing, crimes committed while in the county jail. The 2nd District directed the trial court on remand to reconsider exercising its discretion under Romero, and to consider other ways in which it could exercise its discretion to impose something less than the sentence the trial court itself found to be excessive. It looks like the Supreme Court has granted review to consider whether the 2nd District's approach is consistent with Romero. Next, a case involving jury selection. According to People v. Wheeler, if a trial court concludes that one party has impermissibly exercised peremptory challenges on the basis of group bias, the court must dismiss the jurors thus far selected and quash any remaining veneer unless the party who made the Wheeler challenge consents to retaining the veneer or waives his right to quash the veneer. In People v. Mata, the defense challenged one of the prosecutor's peremptory challenges, and the court granted the defense counsel's Wheeler motion, but the court did not dismiss the rest of the veneer and simply reseated the juror. Although defense counsel did not object to reseating the challenged juror, counsel also did not affirmatively consent or explicitly waive any objection. The 2nd District held it was error to reseat, even though defense counsel did not object. Looks to me like the Supreme Court is going to focus its attention on whether a failure to object in this context is the equivalent of a waiver. Some criminal procedural rights, of course, must be waived explicitly, so the court will get a chance to decide whether the remedy for a Wheeler violation is one of those things that requires an explicit waiver or consent. The court also granted review in an interesting case involving costs. Now, we don't see very many published opinions about what is and is not an appropriate basis for an award of costs. But the 2nd District faced in Martinez v. Brownco Construction a $92,000 cost request for preparation of a PowerPoint used in closing argument, a $12,000 bill for editing of a video deposition played to the jury, and $188,000 in expert witness fees, which were incurred after the plaintiff's first Section 998 offer and before the plaintiff's second 998 offer. So big money here was at stake. Now on the PowerPoint, the 2nd District held that because it contained nothing but argument of counsel, costs for its preparation would be inappropriate. The costs for the video deposition were reasonably necessary, particularly since the jury specifically asked for the video in lieu of a dry readback. And as for the 2 Section 998 offers, the court held the plaintiff was entitled to witness fees incurred from the date of the earliest offer. We'll see what the Supreme Court thinks about a $92,000 PowerPoint. Finally, the California Supreme Court granted review in a red light camera case. We've had a bunch of these in the Courts of Appeal recently. They're not all that popular with the public, and every now and then we see courts throw a monkey wrench at the whole enterprise. That's what seems to have happened in People v. Borzakian, where the 2nd District held that the police officer who handles all of the records regarding the City of Beverly Hills automated red light enforcement system, and who appears to testify at all contested violations, could not authenticate the maintenance records for the cameras, which actually were maintained not by the police department, but by a private company which contracted with the city. Of course, absent authentication, the maintenance logs were not admissible, and absent the logs, there was no basis for asserting the reliability of the red light camera. The 2nd District's decision is at odds with the Court of Appeal decision of People v. Goldsmith, and with a decision recently from the Orange County Superior Court's Appellate Division in People v. Kalin. I noted back on March 2nd in discussing Goldsmith that the California Supreme Court was going to have to step in to resolve these conflicting opinions, because we can't really have lingering uncertainty about the enforceability of traffic tickets based on red light cameras. That's exactly, of course, what we're now seeing the Supreme Court do. Finally, we've got 2 California Court of Appeal decisions, the first involving the jurisdiction of the Coastal Commission. The California Coastal Commission suffered a major defeat in the City of Malibu versus California Coastal Commission, where the 2nd District decided the Commission acted in excess of its jurisdiction when it approved amendments to a city's certified local coastal program at the request of state agencies over the objections of the city, where the amendments were not requested to undertake a public works project or energy facility development, but instead were amendments that changed the city's land use policies and development standards as they would apply to future plans for development within the city. Now, the Commission does have power to override a local coastal program in the context of an approval of a public works project or energy facility development. But it can't simply amend a local coastal program prospectively in the absence of any pending project, which is essentially what the Coastal Commission tried to do here. Finally, a case involving the law of burglary. In People v. Chavez, the 5th District dealt with one of the constantly interesting questions under the law of burglary. What exactly constitutes a building? Now, courts around the country, not to mention law professors, seem to revel in the apparent simplicity of the question. In People v. Chavez, the defendant, in connection with 2 separate incidents, was convicted of burglary, receipt of stolen property, conspiracy to commit burglary, theft with a prior theft conviction, and possession of burglary tools. In the published portion of the opinion, it dealt with the conviction for conspiracy to commit burglary, and that was based on the entry of a co-conspirator into a fenced wrecking yard to steal gasoline from a junk car. As you know, burglary requires entry into a building, but the jury was instructed that entry into the yard was sufficient, and so it convicted the defendant of that charge. Noting that the California Supreme Court has defined building broadly for purposes of burglary, the 5th District explained that it has still generally limited the meaning of building to a structure with walls and a roof, concluding that the plain meaning of the word building does not include a fenced yard. The court reversed the conviction for conspiracy to commit burglary, which cut about 8 months off of the defendant's 9-year sentence. Nice try by the prosecutor, but there still are limits to what constitutes a building. And that's it for today's Kelso Report. Have a great day in the law.